an existing legal aid firm. We have a legal aid contract.
I have practised in family law, which is publicly funded, both as a solicitor and a barrister, but I haven't practised and don't intend to practice at the moment, and haven't practised since April.
To declaration, I used to be a barrister, well, I'm still a barrister, but I used to practice, and I did receive legal aid receipts. I do occasionally still receive them now, not many. And secondly, many, many years ago, I used to be one of the volunteers for the free representation unit.
Yeah, I've not practised publicly funded work since before the election, but I'm still a member of my local chambers in Hull.
Thank you very much. You can assume the rest of us haven't got any interest unless we finish up seeking your help for any kind of trouble. I'm sure that won't happen. Emma Baldwin, Rebecca Scott, Sally Denton, welcome. Between you, you represent the Free Representation Unit, the Royal Courts of Justice Advice Bureau and the Nottingham Law Centre. We particularly asked you to come, we're very grateful to you, to look at how things work out on the ground in practice. The second half of today's session is more about the views which organisations take, national organisations working in this field. But I will just start by asking whether, on the basis of your practical experience, you think that there's no alternative to continuing to, at present or similar levels of spending on legal aid, or whether you accept that the kind of financial situation we have, ways have to be found of limiting the costs of legal aid and advice. Have you got any thoughts on that?
Yes, we do. We are concerned about these proposals because of the wider effects that they're going to have. In terms of the money saving, our first concern is that we don't think the cuts as proposed are actually going to save money. We think that that idea is based on a false premise as to what the effect of legal aid is in the sector at the moment, and we think that legal aid practitioners are diverting cases away from tribunal because they're solving the issues before it gets to that stage. So that's a save, because tribunal time is very expensive, and if those cases weren't diverted, they would end up in tribunal. And of the cases that do get to tribunal, if there has been some representation at an earlier stage, that means that the cases are dealt with more efficiently when they get to tribunal, and again, you're saving court time and the time of the respondents as well, because there's an easier case for them to understand and deal with.
Have you got a rough picture of how much of the income of your organisation depends on legal aid at the moment?
In terms of Nottingham Law Centre, in the financial year 2010 to 2011, legal aid comprises 58% of our total income. It's 308,000 out of 528,000 income. And it's fundamental to us being able to provide specialist advice to people that really need it. If we didn't have that legal aid funding, we wouldn't be in a position to deliver specialist debt advice, specialist welfare benefit advice, which in turn ensures that people don't face possession proceedings and homelessness, that people can continue to care for their children, don't need to involve social services in their lives. It enables us to nip problems in the bud, getting people advice when they need it.
Do you have a supplementary point?
I do, yes. I just wanted to understand what you think the cost drivers are of legal aid. So is it partly the legal system and the way we go about things? Is it the cost of lawyers? Is it broader social issues that are driving the cost? How would you describe, what are the key cost drivers of the legal aid bill?
So research that we undertook within the Nottingham advice sector identified that about 42% of the work that we did was caused by system failure in other organisations. So that was poor decision making in other organisations such as the Benefits Agency and Housing Benefit Departments.
Systems failure rather than a judgment, an unsatisfactory judgment being made.
Saving, can you?
But there are lots of examples of, for example, delays within the Housing Benefit Department, which then cause rent arrears, possession proceedings. We've had cases that have necessitated 3 or 4 adjournments to enable housing benefit issues to be resolved, which represents a huge cost in terms of court time, in terms of social landlords' time, and in terms of legal aid spend.
Good morning. Can you give us examples of private law cases which will now be outside the scope of the legal aid scheme? And what, in your view, will be the impact on these families concerned?
I can give an example of that type of case. I don't have a legal aid franchise at my charity, so I contacted a colleague at another charity. She's a family lawyer with a legal aid franchise. And she gave me a case study of the new proposals. Basically, in this case, her client has suffered long-term domestic violence from her partner, and they had children. She'd left her partner, and he did not know where she lived. And she came to us for advice a year after he'd left, because he wanted contact with the children. Under the new proposals, she wouldn't have been able to get legal aid because the partner had never been convicted and she'd never obtained a previous injunction against him. And because he didn't know where she lived, she wouldn't be entitled under the new system for legal aid, as there wouldn't be any merit. So in that situation, now under the new proposals, she would have to go to court alone and face her abuser alone, and probably not defend the case very well. And in that situation, under the new proposals, a full contact order might be made, which would be wholly inappropriate for a partner that's violent. As it was, they defended the proceedings, and a supervised contact order was made, and the contact takes place in a supervised environment. So that's hopefully highlights the difference under the new and old proposals, and how potentially dangerous these changes will be.
And that case is not unique by any means, is it?
No, no.
Does anybody else want to address the point?
Certainly, in terms of the work that we do, we would be very concerned about some of the proposed cuts in terms of welfare benefits, because we see people who are experiencing periods of time where they're, for example, in receipt of nil income because of decisions that have been made regarding their right to reside and immigration status, which are very complicated issues. If we can resolve those, then we can prevent those people from falling into rent arrears. Increasingly, we're seeing people who are living in private rented accommodation where there are mandatory grounds for possession available where there are rent arrears. And so even though under the proposals possession proceedings will still be covered, the reality of the situation is that once it gets to possession proceeding stage, there won't be anything that we can do to prevent an order for possession being made because it's mandatory. So the only way to prevent those people from being evicted is to get involved at an early stage to help them to deal with what can be extremely complicated welfare benefits issues. And if we can't get in there, then there is a huge cost in terms of the cost of eviction, and if it involves a family, the cost of rehousing that family as homeless, the knock-on costs in terms of their education, and their knock-on costs in terms of the implications for social services. We get referred clients with welfare benefits problems by social services because they know that if the clients don't access assistance in obtaining their welfare benefits entitlement, that the costs to the social services department will be increased because they will be the ones that have to pick up the pieces under, for example, Children Act duties.
The Green Paper, of which you will be aware, states that the provision of legal aid in this area is creating unnecessary litigation and encouraging long drawn-out and acrimonious cases. And further, it says people should take responsibility for resolving such issues themselves, and that is best for the parents and children involved. How do you respond to those statements?
Before we can take on a case that's publicly funded, we have to undertake a sufficient benefit test. We have to look at the case in terms of the costs relative to what we can achieve for the clients and the likelihood of success. We have to apply a test as to whether a private paying client with moderate means would be advised to take on that case. We also have key performance indicators that require us to demonstrate that we've achieved a successful outcome on 40% of our cases. We won't take cases on that don't have sufficient benefit. Our service is oversubscribed as it is at the moment, which drives us to try to achieve early resolution. We don't want to go to trial if we can settle a case appropriately before then. And in fact, what we would say is that the reverse is true to that. Clients whose cases are appropriately funded, that are prepared appropriately right from the start, are likely to resolve without the need for litigation. And certainly, even if litigation has started, they're likely to settle without the need for trial. So I would say that the provision of adequate funding actually prevents more litigation than it causes. And as I've already set out...
I'm sorry.
A significant proportion of the cost drivers are from outside our organisation in terms of the system failures within other organisations that drive litigation.
Can I just check something with you which arises from that? You talked of your key performance indicators as if they're measuring a successful outcome for the client. But from a public point of view and the disposition of public funds, surely a successful outcome is that the interests of the child are best looked after, and public money isn't wasted in competitive processes between two parents arguing over access to their child, who ought to resolve this issue without getting into legal proceedings.
I disagree there. I think that's where the law is there to protect children, and early intervention in family proceedings can reduce protracted...
I'm talking about private law cases now. Specifically about private law cases.
Well, we're concerned with legal aid, the withdrawal of funds from legal aid funded cases.
In the statement which Mr. Thuid quoted, the government made about private law, private family law
There's
cases.
certainly a very strong argument to say that involving advisors at an early stage takes quite a lot of the acrimony out of issues, and it enables people to step back and deal with things in a much more rational way. Certainly, I don't do family, but I take action against private landlords, and sometimes those cases are much more protracted because of an unreasonable or entrenched position that those people take. If they're legally represented, it generally means that cases are resolved much more satisfactorily, much more quickly. And if the parties are going to have some ongoing relationship with each other, then it's in everybody's interests that those relationships are the least acrimonious going forward as they can be.
But it still remains, of course, that there will be a percentage of the hard cases where nothing can be agreed, and it would have to go to tribunal to be resolved. Nothing can be done about those, presumably.
Yes, but I think it's still a better resolution for everybody if there's equality of arms when the parties do go to tribunal. And I think if one party is weakened by being unrepresented and they're forced into a terrible settlement for them and their children, you have all those secondary problems then of debt issues, mental health issues, and possibly, worst case scenario, having to rehouse someone that's been made homeless. And I think children suffer far more in those circumstances than by having a parent with a lawyer that presents their case fairly.
And sometimes you do need the court or the tribunal to settle the matter. I mean, that's...
This follows on what Ms Denson said earlier on. How much of a contribution do you think that mediation is making and will be making in the foreseeable future?
We think it's a valuable component of legal advice, but we don't think it's the only component. We've got concerns that only a small amount of mediations do resolve issues. The research on mediation, there hasn't been much of it, and we think the impact's unknown. And we're concerned again that some parties might be pressurised into settlements that might not be suitable for them because they don't have proper representation when they go into the mediation. And ultimately that might result in parties going back to court anyway to try and enforce agreements that were made in the mediation. So I think our position is that there isn't much research on mediation, and we think it's a valuable component, but we don't think it's any substitute for proper legal advice.
A quote from Elizabeth Truss before I move to Yasmin Qureshi.
On the subject of legal aid, you mentioned that there's a lot of cost coming from external agencies. But it seems to me, if you look at the international statistics, we're not only expensive in terms of the number of legal aid cases that are fought, but also the cost per case. Why is the cost per case so much higher in Britain than it is in equivalent countries with similar legal systems? Because that can't be the fault of the benefits agency or external parties. That's an issue to do with the legal process, isn't it?
If you take a case involving possession proceedings for rent arrears, if, as frequently happens, we have our first contact with that defendant as duty solicitor because they've not been able to access legal advice prior to then that case will need to be adjourned to enable housing benefit issues to be resolved. And potentially, if those issues are not resolved quickly because of delays within other organisations, then that case will be adjourned again and potentially again, and on some occasions 3 or 4 times. And that will, in turn, drive up the cost of that case. For the landlord, social landlord, to get possession where there are rent arrears, they have to establish that it's reasonable for a possession order to be made. It's not reasonable for an order to be made whilst benefit issues remain outstanding. So those issues have to be allowed to catch up before a decision can be made.
Is that the only reason that costs are so high per case? Are there things that can be done within the legal system to reduce the cost per case? I didn't wonder if the other witnesses could comment as well.
I mean, my answer is more of a question, and I wonder if the government has considered legal aid cuts. It seems that they've been considered in isolation, and I wonder if there's been looking at the efficiency of the actual Legal Services Commission and the way it's administered, because it does seem to be quite a bureaucratic, inefficient system that frustrates solicitors and legal practitioners. And it seems that the government has just considered these cuts in isolation without looking at other savings across the board.
So what would you do to the Legal Services Commission to make it efficient?
Not being knowledgeable enough at it, I would have a look at its processes and ask practitioners what is slowing the process down and where it's going wrong, basically.
So you're saying it's the
order. I think I really must give Yasmin Qureshi a chance.
Could I just come on to ask you, typically what kind of people do you assist with legally aided social welfare cases? And if the free advice wasn't available to those, what would be the impact on those people?
A high proportion of the clients that we see at the Law Centre in Nottingham fall within the vulnerable bracket. So they are people with long-term health problems, and including a significant number of people who have been diagnosed as terminally ill. We see people with learning disabilities, with mental health problems. We see a large number of people with substance and alcohol dependency issues. We see people with language problems, people who have recently come to this country and are not familiar with systems. We see single parents with little support networks who are very isolated. But increasingly we're seeing people who have totally lost confidence in their own ability to deal with their problems. So we see people in debt who have got to the point where they won't even open their post, they won't answer the door, and they won't answer the telephone because they cannot deal with the situation anymore. We see people in relation to benefit problems who have no income at all, and they have no income at all for protracted periods of time. So these are not people who can't be bothered to take responsibility for their situation. They're people who can't take responsibility for their situation, and sometimes they just need a bit of help to get back on the right track. These are people whose circumstances frequently impact on their ability to maintain a basic standard of living for themselves. It impacts on their ability to parent their children, to maintain a roof over their head, which are fundamental and basic needs that they have. And in our view, a continuation of the situation impacts on their health and the cost in terms of maintaining their health and healthcare services. It impacts on the cost of their children's education, and it also impacts on their chances of returning to work and returning to play a productive role in their community.
Legal advice they need, if
Yes.
those are the circumstances.
Yes, because quite often you will find that what underpins the problem is somebody who has repeatedly tried to secure the benefit entitlement that they should be receiving, and they haven't been able to obtain that. And it's set in place as a safety net for people, and there are people for all sorts of reasons, including poor decision making, that haven't been able to access that basic level. It's the same with debt. There are people who are struggling to deal with debts where a lot of those debts are challengeable, where the practices of the lending institutions are questionable. And people need an opportunity to be able to challenge those, to be represented, because those issues are underpinning their whole lifestyle, all their finances, and they have a massive knock-on effect.
Any others want to add? Sorry, any others want to add to?
I was just going to add to that when people come to see us, they are in a crisis point with their legal problems, but resolving the legal problem can be the first step in turning their whole lives around. And my advice centre has a very much holistic approach to problem solving, and we have all different projects. And once you've resolved court proceedings, hopefully satisfactorily, we'll refer out and they'll get debt advice on how to maximise their income, how to manage a budget, and hopefully coming to us can be the first step in turning things around, even though it might be seen as legal advice.
And the advice we give is legal advice because people have legal problems. They have cases in front of the Social Security and the Employment Tribunal. Their cases often deal with complex matters of law, and they have to present evidence and they have to present their case in a way in which they are not able to do, they're not used to doing. The normal processes of tribunal in terms of fact-finding and putting forward the important points that need to be made and evidencing those when they can. People don't know how to do that without assistance. It's not something that people naturally know. And so they need, it's legal advice that they need, and that's what we provide for them.
Yasmin?
Yeah, and leading on from that, is therefore, would you accept, as we've seen written evidence to this effect, that helping somebody at the earliest stage prevents more expensive problems occurring later on? Would you agree with that?
Absolutely.
In terms of debt, we see, I see a lot of clients who are facing, for example, mortgage possession proceedings, and had they been able to get debt advice at an earlier stage, they would have prioritised the roof over their head. They would have been able to explore challenging other debts, maximising their income, and they would have been able to explore other ways of resolving the situation, like capitalising arrears, extending the term of the mortgage. But none of these things are available by the time we see the person at possession proceeding stage. So quite often the situation has become so entrenched by then that we can't avoid them being evicted, and then that has huge knock-on costs in terms of other departments. Similarly, the issue with getting early advice in relation to benefits, that saves all sorts of costs in terms of possession proceedings and eviction.
We deal with cases are referred to us when they have a hearing date, so we get involved quite late on in proceedings, when often there's only a number of weeks until hearing. But we still find in that window of time we can make quite a big impact, sometimes with our welfare benefit cases. When submissions and evidence are made, the judge decides on the papers in favour of the client, and the hearing can be vacated. With our employment cases, we found about 50% of them settle. We manage to settle them between the point at which we get them and the hearing date that's scheduled. So intervention at any stage can help to resolve the matter, and the earlier the better.
Can I just come on to one of the reasons given in the Green Paper for removing welfare benefits from the scope is, and I quote, "These issues are of lower objective importance, because they are essentially about financial settlement than, for example, fundamental issues concerning safety or liberty. How would you respond to that?
As I've already said, we increasingly see people who are excluded from benefits in their entirety, and that's likely to increase as we see increased job seekers allowance sanctions, which will be potentially for up to 3 years. Those people are therefore receiving no income, which must have implications in terms of their health and safety. Additionally, we see people who are not in receipt of nil income, but because they're not receiving all of their benefit entitlement, are not receiving the protection that the benefits entitlement safety net should be providing to them. So there is a safety net for people in the form of welfare benefits, which it depends on their circumstances. And there are a significant number of people who are not able to access that safety net. And that may be due to language problems, health problems, it may be due to poor decision making. And it's fundamental to their whole life that they are given help to resolve those issues. These are not necessarily straightforward issues. The welfare benefits legislation in some areas is incredibly complicated. The right to reside issues are changing all the time. It's very difficult for somebody who's not a specialist advisor to keep abreast of the changes. Housing benefit legislation is terribly complicated.
Can I just clarify something from that? It's really around the question, do you need to be a fully trained and experienced solicitor in order to handle these matters, or is the practice not, even within your organisation, that much of this advice will be given by people who specialise in it, but not on the basis of being legally qualified, either as a solicitor or indeed as a legal executive?
Within our organisation, we have some generalist advisors, and they are able to give advice in relation to some of the more basic issues surrounding benefits. And so those are not issues that are dealt with by our specialist team. But the specialist team are dealing with interpretations of legislation, which is incredibly complicated. They're looking at case law, and they're looking at law not only in the area that directly relates to the benefits, but in relation to associated issues like immigration. And so it does need people with a high level of qualification.
And relatively speaking, there's a very small percentage of solicitors who are adequately qualified.
Yes, there aren't very many people that deal with welfare benefits at all. Which is why, for example, in Nottingham, a lot of work has been done in mapping need and making sure that advice is delivered by the right people, so that we try to avoid specialist advisors giving basic level of advice, because there aren't enough specialist advisors. We want the specialist advisors to be dealing with the complicated issues that involve interpretation of legislation.
I mean, I would add, I think that in the social security sector, the practitioners, some are legally qualified, solicitors, barristers, others aren't, but the specialists in that field are all highly skilled and highly experienced. And it's not so much your qualification that matters, it's your knowledge and experience of that particular area of law, because it is so specialised, and it's an entirely self-contained statutory scheme. And general legal concepts are butt against it from time to time, but essentially it is a universe of its own, and it's your knowledge and your ability to keep up to date and to work around within that knowledge base that's important.
Harry had a point.
Thank you. Thank you. And I think we all actually suffer, as well as MPs, from the complexity of these issues. And I know certainly refer many of my constituents to the CAB and to their legal teams. But if we start from the premise that we have to reduce public spending and we have to work out the best way to do that, one of the things I'm struck by is all three of your organisations are sort of doing similar things and helping similar people. And of course the CAB is also doing that through its specialist teams. And I'm wondering, what do you make of the proposals for potentially streamlining, working together, potentially using a telephone advice service? Have you considered those as a collective group, or have you rejected those entirely? Because I think we would like to keep
this access available, certainly to people who find it difficult for various reasons to access what is a very increasingly complex world of benefit entitlement. But what we'd like to see is whether there are ways to do that in a more streamlined fashion. I'd be very interested in your comments on that.
I think that it is important that things are dealt with at the correct level. I do accept that there are basic queries that could be dealt with at a generalist level. I don't think that the telephone gateway is the appropriate way of directing people to advice. I think there is room for telephone advice to complement face-to-face advice, but I have considerable concerns about the proposals in terms of telephone gateway. There is both the idea that will be the only way into advice, and also that there is an assumption that a lot of specialist level advice can be delivered by telephone, and that is going to present considerable problems to a lot of the clients that we see. Telephone advice doesn't suit everybody. It does suit some people very well, but it doesn't suit everybody. It doesn't suit people who lead chaotic lifestyles. It doesn't suit people who don't speak English very well or have other barriers to their communication. Telephone advice is only as good as the information that advisor is given by the client. And so there are lots of situations where clients don't present their issue in a particularly coherent or accurate way, and therefore the advice that flows from it isn't going to be particularly helpful or accurate. So clients will, for example, inevitably say, I've got an eviction, but that can be a letter saying that they've got rent arrears right through to the bailiff appointment, and unless you can correctly identify the stage that they're at, the advice that flows from that situation is not going to be helpful, and the decisions about where that person needs to go for advice are not going to be appropriate. And there are also issues because we are, as a law centre, firmly entrenched in our local community, so we understand the pressures that people are under, we understand the organisations, we have a lot of referral networks who bring clients to us, we have clients that come back and we know the background of their case, and we are able to address issues that crop up time and time again because we can see patterns, and then we can campaign generally in relation to those which resolve issues and save costs. And all of that local knowledge and understanding communication networks, the ability to settle cases early because we know the people involved, will be lost by the telephone.
Well, forgive me, I'm sorry, I must challenge. I mean, it's a little bit like being an MP in a way, in that you do have the same clients that present again and again with problems, and clearly there are some people for whom they don't understand the documents, they don't understand the immigration law. But, you know, you can also polish off an awful lot of people in a phone surgery who perhaps present with slightly less complex cases. And so is there not a role for triaging perhaps a little bit more in a way to ensure the resources, the face-to-face resources, are targeted at the most needy people? And perhaps think a bit about how we can
This question's fairly brief because we have a lot of more things to get through.
We think it has a role, but it's just one part to play in a whole provision of legal services. Also, there's an assumption that we're all going to be here to provide a service, but all our funding's under threat. So that's a really decreasing picture, and our services might not be here next year. So to assume that we're all going to be here to pick up the pieces, I would disagree with that assumption. The pro bono sector is under attack at the moment, and all the services that we rely on are being cut. So,
and we're not all doing the same thing. At FRU, we provide representation in tribunals that is not covered under legal help or under legal representation. And we are providing a joined up service with legal help providers and agencies who have some of their funding from legal help, some of their funding from local authority, some from charitable funds. And our business model is based on agencies of that type sending cases to us when the appropriate case at the appropriate time. So we make sure it's the right type of case, that the client wants to be referred, they photocopy all of their documents, and they send those in to us. We get 1,600 of those a year in the Greater London area. Now, a lot of that work is done by our partner agencies who send sending those cases in is a big chunk of work that they do. If they don't survive with legal aid funding going, because if it's a strand of someone's funding, that could be the final straw. If that goes, the business could then become unviable, or certainly it might have to retrench and become smaller and limit the type of work.
Presumably some of them have already had their matter starts reduced by the LSC. That you had that experience. I need to come back to Yasmin Qureshi, who had the question.
One final question. It seems that a lot of immigration cases will be removed, bar those who are detained, from the scope of legal aid. What do you think will be the impact of removing these cases?
Well, we welcome the fact that asylum and detention has been kept within scope. We think that's vital. For those that are out of scope, all I can say is that I can't think of any support services that are going to be there to support them. And they are a very vulnerable client group because of generally English isn't the first language, just to start. But I can't think of any other charitable agencies that are going to step in and fill that gap. To my knowledge, there just aren't any. And I wonder if that will make the immigration tribunals more or less efficient. My suspicion is it will make them less efficient, although I've got no hard evidence to.
They could have more appeals, couldn't they?
Absolutely.
Mr. Evans.
Yes, the Green Paper recognised that its proposals will lead to an increase in the number of litigants in person. What potential problems do you see arising out of this?
Well, the research shows that people without legal representation are more likely to pick a more formal route to resolve their problem rather than consider ADR. They're more likely to litigate less effectively. They're more likely to make mistakes. They're more likely to request an adjournment. All this racks up time and cost for the courts and also for the represented client. They're more likely to have a less fairer outcome and therefore more likely to appeal. And they're more likely to put pressure on court staff to provide legal advice, which they're not qualified to do, which again leads to mistakes. So there's nothing really to support having a client without representation, and early intervention and early proper legal advice is always beneficial. If a client has proper legal advice at the start, they can get advice on whether there's merit to the case, and with that advice they might actually be less likely to litigate than going into it blindly without that early intervention. So there's nothing to support having someone going to court without representation, and I'd say for 95% of the clients I see it's impossible for them to do that for a variety of reasons.
I want to explore that point further about clients not being able to represent themselves. Now, the Green Paper says that tribunals are user-friendly. Now, I come from a trade union background, and I had a number of my members experienced trade union representatives who frankly found the whole experience very daunting. Now, with the people you work with, how would they find that process? And if all three of you can make a comment, that would be very helpful.
Well, we think that in tribunals, panels and the judges in particular do make a great effort to enable litigants to take part in the process. And they are less formal than a court hearing, but that's only in relative terms. They're less formal, but they are still formal fora. And for many of our clients, that will be the most formal meeting that they ever have to attend. And people do find it daunting and do find it frightening and sometimes can't face going. And actually one of the values of having a representative present is that the client is then going to turn up because there's somebody with them. And that's going to enable the tribunal to use their inquisitorial jurisdiction and find out what is going on. We'd also say that the formality or lack of it isn't really the most important point. The reason that conducting litigation is difficult for people is because they have a very real problem that's very important to them that they're trying to resolve, and they're in a situation where they often don't understand what's going on and they can't follow proceedings, and that's the problem. It's not whether the tribunal are friendly or whether they're sitting, on a raised dais or on the same level. It's the ability to engage with what's going on.
The experience I found was that when you're mixed up in a case and it's your case, you take ownership of it, it becomes very emotional. And a lot of the problems that I faced as a union official was that people couldn't seem, felt, even if the panel was very friendly and they were dressed down or whatever, they still felt that they were sitting in judgment upon them. And that was a huge problem. I don't know if that's the same thing with your clients as well. Do you feel like that?
Yes.
I know that's more of a statement than a question.
They are, but I mean, that is the judge's role. And the judges can be as friendly and as enabling as they can, but they have a number of roles to play in the tribunal. And one of their roles is controlling the court. And that often involves controlling the litigants. So they do have a judgment role. And people do find it very upsetting and very emotional. And often having representatives involved immediately helps to lower the emotional temperature in the room, and it lowers the emotional temperature in discussions. And that's particularly with employment cases. Your chances of settling, if you've got both parties represented, absolutely skyrocket. It's just much more difficult if even one of the parties...
Many of these tribunals intended originally to be fact-finding bodies which did not expect to have representation at them. And is it not the case that increasingly we see the need for there to be some kind of appeal mechanism for all kinds of decisions? And so a tribunal is set up for that purpose, but not on the assumption that there's going to be a vast expansion of legal representation commensurate with this growth in appeal mechanisms.
Just because the procedure is straightforward, it doesn't mean that the law that underpins the decision is straightforward, and that's why people need representation. It's not always to stand up and speak, it's to assess what their basis of their challenge is before they even get to the tribunal.
In industrial tribunals, I mean, as Sir Alan says, the whole idea was a fact-finding tribunal, keep it simple. It's now developed almost as a separate system from the courts. And when I began in practice, Harvey's on Industrial Relations was the main book, a single volume. It's now 5 or 6 volumes long, with case law as much as you'd like. So it's just become so complex that it's daunting for any individual without help, isn't it?
Yeah. It's not easy law as well.
No, that's right.
So we took the question from Mr Evans.
Oh, sorry, Chris.
Would it be fair to say then, and I'll finish here now because I know time is moving on, in tribunals where the DWP and most employers have legal advice, would you say that taking away help preparing for hearings would put appellants at a severe disadvantage?
Yes, they would. But I think it is important to bear in mind that what is being provided at present. People get legal aid, which helps them to prepare their case, but they don't get help with representation. Some solicitors do the representation pro bono, some law centres and other organisations match fund so they can afford to attend tribunal with their client, but it's actually not being met by legal aid. And then there's organisations like ours that do representation.
That leads me on to a point for you, Ms Baldwin, which is that your website says that the Green Paper gives a misleading image of the free representation unit when justifying the removal of legal aid on the basis that there are alternative sources of assistance like you available. What would you like to say about that?
We do. If you just bear with me. The issue we had with the statements in the consultation document, they're at paragraph 4.218 and at page 193, were that there was an implication in what was being said that the cuts in welfare benefits provision could be ameliorated by our organisations and organisations like that, like us. Our first point we wanted to make was that we don't provide initial advice, so we don't do legal help work, which is what is being proposed to be cut. And in any event, the pro bono sector has a small role to play. And we're very proud of our work and the work we do. In terms of welfare benefits, we represent in about 500 tribunals a year. But currently there are 339,000 Social Security Tribunal cases in the system. So the work we do is small in comparison to the overall picture. And as far as pro bono organisations go, we think that the volume of work we do is very high. We're not aware of anybody else doing work at that rate or at that level. So we were concerned really about the scale issue and an implication that we might be able to fill the gap, and we're just not in a position to plug the gap that would be left if welfare benefit provision was reduced to the extent that we fear it might if these cuts go through.
And yours is a service which is essentially provided entirely voluntarily by those involved?
Yes, our volunteers. We have around about 500 volunteers active in any one year. They're largely students and young lawyers, and they do the bulk of the representation that we provide.
That's what I did as well years ago when I was a law student and started doing free work.
Is there more scope for expansion of this kind of help, this kind of voluntary help?
Through help, I mean, we are keen to expand as much as we can. We currently have a small pilot project running at Nottingham Law School where they're undertaking a small number of employment cases a year. We are in fairly advanced talks with Birmingham Law School, and we've also been speaking to Manchester, although I understand some difficulties occurred there because of the last legal aid bidding round that didn't turn out as we'd hoped. So we are trying to expand, but as I said, this is going to be small numbers of cases overall, and it isn't the answer.
Have you had any discussions with any part of government in the context of the consultation, either the Ministry of Justice or any other government department, about the role you might play if these changes were to go ahead?
I don't believe so.
We've responded to the consultation paper. We'd like to make the point that all these law centres and charities that you rely on as an alternative do require funding. It's a small amount of funding, but they need an infrastructure and they need to be well organised. The law firms that volunteer for us say they will only participate if it's a well organised scheme that's funded and has an infrastructure. They're not going to spend their time on pro bono work if they're not committing to a scheme that's well run and funded. And all pro bono agencies are under threat of funding at the moment. The Financial Inclusion Fund was abolished last week, and 7 of our debt advice workers were immediately made redundant. So that the image that we're all going to step up and fill the gap is dependent on funding, and a lot of that funding is legal aid funding or Legal Services Commission funding. So we're under threat just as much as legal aid firms.
Yeah. And charitable giving is also under threat, and since the credit crunch, we are 1.5 trainee solicitor posts down in the office, where firms used to send us a trainee solicitor for part of their training contract, and we are 1.5 down already. So there is already a contraction because of the wider economic situation.
If we look in Nottingham, if these proposals go ahead, then in terms of welfare benefits and debt, there won't be any specialist providers because they're all Legal Services Commission funded. In terms of generalist advice, that's local authority funded. The county funding has all gone. The City Council is not going to provide additional funding to meet that gap. If anything, it will cut its funding. And these are not clients that can afford to pay for advice from private practice firms. It's not the type of advice that's attractive in terms of CFA arrangements. And in terms of advice through supporting people and tenancy support, that's all going too. So if we're not there, there isn't going to be anybody else.
When you talk about debt advice, you said that there would not be any debt advice.
There won't be any specialist
because it's based on an
advice.
contract.
Exactly. And similarly, the specialist debt advisors in Nottingham are all the people, for example, who are DRO accredited intermediaries. So they will go. So in terms of that as a solution to people's debt problems, there won't be advice for people in relation to that.
There will still be provision, again, via CAB caseworkers who are trained often in debt and welfare issues, is my understanding, indeed, in their submissions.
The specialist advice from the CAB is funded by Legal Services.
Exactly.
We're going to be talking to CAB in the next part of
but again, it gets back to the Chairman's point about, is there, and I'm not disagreeing with you, and I think this is clearly a huge problem, but I mean, there are levels, if you like, gradations of debt advice. And again, this is often, as you reference, people in chaotic situations who don't have particularly tricky legal problems have issues around, we've read all very good examples in the submission, issues around around sorting out what's a priority versus a non-priority creditor, which does not require a solicitor's qualification to do. That's what an experienced caseworker could do. So the statement that there is no debt advice available is perhaps a bit misleading. There will be less funding for legal assistance with debt advice, but there will still be debt advice available.
Well, it won't be funded debt advice.
They still need paying.
Yes, but the CAB is only 15% of the CAB's income stream comes from the legal aid.
We have the CAB in later, so we can ask them that question. Thank you very much, the three of you. We're very grateful for your help. And we have some further witnesses who I hope are all here already.